All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and His honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have 3 cases on the calendar this morning, and we will take them in the order in which they are presented. The first case is in re Willie Richardson. Counsel, you may proceed.
Good morning, and may it please the court. Anna Maria Kimball, pro bono counsel on behalf of the appellant, Mr. Richardson. And I would
Good morning, Ms. Kimball. And before you get started, I want to thank you and thank your law firm Skadden for being available on short notice to step in and handle this appeal on the withdrawal of prior counsel.
Thank you, Your Honor. I would like to reserve 3 minutes.
That'll be fine.
Thank you. Mr. Richardson challenges the number of convictions he received as well as the admission of his voicemails as Drew evidence. As a preliminary matter, I plan to rest on the briefs with respect to the Drew issues unless Your Honors have any specific questions. With our time today, I would like to address why Mr. Richardson's Facebook messages, which were sent over a short period of time and as a continuous monologue, cannot support 4 separate convictions under both the Double Jeopardy Clause and the Intrafamily Offenses Act. I plan to turn to both of these arguments in turn, beginning first with the double jeopardy argument and then turning to the issue of statutory interpretation. However, as an initial point, I would point out that the government must clear both hurdles in order to prevail. Under the Double Jeopardy Clause, multiple convictions arising from the same act or transaction under the same statute are prohibited. If such a continuous act gives rise to multiple convictions, those convictions must merge. And the court uses the fork in the road and the fresh impulse test in order to determine whether an act is indeed continuous and ongoing. Those tests incorporate a number of factors, all of which must be examined from Mr. Richardson's perspective, and none of which are alone dispositive. Here, all factors militate in favor of a single conviction.
Have we ever had, to the best of your knowledge, is there any case where I think the shortest gap in time between these messages is an hour and a half? Has there ever been a case where we've said an hour and a half, 2 acts that happen an hour and a half apart? There has not been a fork in the road between them that would have permitted conviction on 2 separate offenses?
Well, as a preliminary matter, I would point out that under Owens and Marquette Bryant, time is not necessarily dispositive. Sure. But to answer your question, to my knowledge, none have explicitly said that an hour and a half gives rise to a fork in the road per se. But I would point this court to the Guevara case, in which threats made over the course of an hour-long abduction were all considered to arise from the same course of conduct. And I point that out to show that it does not need to be an instantaneous or rather simultaneous course of conduct to qualify as one ongoing offense under the Double Jeopardy Clause.
But in the case that you just mentioned, I mean, you can see sort of akin to an instance where there's an assault. I think that was the example the government gave in its brief, where multiple blows are thrown, right? You wouldn't charge someone with each individual blow. You would say there's one assault over a span of time, right? And similarly, if there's one abduction and there are threats made during the abduction, you could see charging that as one count of threats. But it strikes me that this is much more like, sending 4 different letters, right? You type up the letter, you put it in the envelope and you put that in the mailbox, and then you type up another letter and you put that in an envelope and you put that in the mailbox. I mean, these are separate Facebook messages. It seems like we should treat that differently.
Well, I think that these, we have to keep in mind that we're operating in the digital space, and that is rather distinct as opposed to, or compared to sending regular mail. And here, Mr. Richardson's Facebook messages were all compiled in a single thread. And I think that that is a distinguishable factor where he was continuing the same conversation, and all of his messages appeared sequentially one after another without any break or any response. And
now, I'm not sure exactly what the state of the record is on how these threads are compiled. Although I assume if Mr. Richardson has not contacted his ex in the last, since this happened, however many years, and he sent her a message on Facebook today, it would still show up in the same thread. Do we know if that's true or not? I think that's generally my understanding of how Facebook messaging looks. I'm not sure if the record supports that, but is that right?
Right, that a Facebook message, sent on day 1 and day 35 or year 35 would come in the same thread. But I think that, under the fork in the road and the fresh impulse test, it's very fact determinative. And so the court need not draw a line as to when a communication becomes multiple via Facebook Messenger. Rather, the court should examine these facts before it today. And I think that those facts support that this was an ongoing communication. As described.
I'm sorry to interrupt, but we have to draw lines, right? To figure out on which side of the line this case is. And I'm trying to figure out what your line is. So you're focusing on the fact that this is in the digital space. And I'm wondering sort of what does that mean? And, if a message on day 35 is going to appear in the same thread as a message from 35 days earlier, where is the line, right? Are you saying that someone would have to sign in and out of Facebook perhaps to, even if it's in the same thread, if you could show that he sent a message, signed out, then signed back in, sent another message, that would be enough for a fork in the road? Or would you agree with that?
Well, I think if we're drawing a line, then it also warrants discussing all of the other factors that are incorporated into these tests. So one such factor is that they were all directed at the same individual. They were made through the same mode of communication. The messages were sent on the same day. And as was pointed out, generally within an hour and a half of the immediately preceding message. They all related to the same subject matter, and they all invaded the same legal interest.
So I have questions about it. Sorry, please.
May I ask you, does the record indicate when the recipient received these messages?
No, it does not, Your Honor. The record does not state either way whether the recipient viewed them all at once as they appeared in final form, or one after another in real time. The record is absent.
See, I'm sort of wondering, when you said that, suppose the recipient did not see these messages until all 4 of them were in the thread and in her computer, cell phone, and rather than having seen the first one and then seen the second one and then seen the third one and so forth. In your view, would that make a difference?
Well, I think that if the recipient saw them all at once, that might strengthen our position even further. But I don't think that if the recipient saw them sequentially, it detracts from our position. And that's because under Marquette Bryant, the factors are to be analyzed from the perspective of the defendant. And so here, Mr. Richardson had no opportunity to know whether or not Ms. Hargrove was receiving the messages in real time.
So I just want to push on this a little bit. So if I can point you to page 50 and 51 of Ms. Hargrove's testimony. And also page 55, the questions are, what time did you receive the first message? She says 2:09 p.m. What time did you receive the next message? 3:39 p.m. Now, one reading of that might be, oh, what she meant is that's the timestamp when the message came through, but she might have seen them all at once. But that is not the reading that's most favorable to the government's view of the evidence, which is how we have to view it on a sufficiency challenge. And I know this is not quite a sufficiency challenge, but I think we would take the evidence in the light most favorable to the government and say, there is evidence that she received each of these separately. Now, you said we don't know when she received them, but the evidence is, what time did you receive them? And she answers 2:09, 3:39. Then the next one wasn't until more than 4 hours later at 7:37 something. So why do you say there's no evidence about when she received these messages?
Apologies, Your Honor. I meant that we don't know if she, in fact, read them in real time. I understand that her testimony used the word receive. I interpreted that as the time that they were pushed through to her Facebook Messenger inbox. But I understand that it could be viewed as she read them at that time. But even if that's the case, Mr. Richardson did not know whether or not she was seeing them in real time.
And see, I don't know what the evidence on that is, though. I mean, one natural inference is, I think Facebook might send read receipts and say, read, seen. But because there was no challenge to her testimony that she received them, she says, I received one now and one next. Like, none of this is developed in the record. So I don't know how we could say, Mr. Richardson, you might just say the burden's on the government and they didn't establish when she received them, though I have doubts about that. I guess I just don't know how we can say that there's no evidence that, that he knew that. It wasn't, the defense didn't make any hay out of that. It didn't say that, it didn't seem to think it was pertinent. It didn't develop evidence. It didn't ask, it didn't put Mr. Richardson on to say, oh, I thought she hadn't received any of these things. There's nothing about that. Is your answer that in the absence of evidence, that all cuts against the government?
Well, my answer is that even so, the factors examined from Mr. Richardson's perspective, even setting that aside, break in his favor. And that's because for a number of reasons. We've talked about the passage of time and that the passage of time viewed in context of a Facebook message or electronic digital communications, conversations can be carried out over the course of multiple hours when there is no response. But there are other factors to consider as well. For example, there was no intervening event in the course of this digital space. As we've discussed, Ms. Hargrove did not respond to him. And Spain and Gardner both tell us that an intervening event can give rise to a fork in the road, and that's notably absent here. Another question is whether the Facebook messages invaded the same or different legal interests. And here they all invaded the same interests because they did in fact violate the same TPO. It's not contested that they all occurred at the same location, which is Facebook Messenger, rather than various forms of social media or other ways of communicating. And they all were directed at a single individual, that is Ms. Hargrove. And finally, they all referred to the same subject, which is the nature and circumstances surrounding Mr. Richardson and Ms. Hargrove's breakup. And so
Ms. Kimball?
Yeah.
Oh, I'm sorry. Well, I don't mean to interrupt you. We're getting close to the point where you reserve some time. But quick question. When you started your argument, you said that you were going to argue not only the double jeopardy clause, but also, and it sounded like separately, a statutory argument.
Yes,
that there had to be only one conviction. Can you explain what you meant by the statutory argument?
Yes. So Our argument here is that the Intrafamily Offenses Act is ambiguous as to the unit of prosecution. And as a matter of statutory interpretation, when a statute is ambiguous on this point, the rule of lenity applies, and the statute must be read in the least onerous fashion. So here it's ambiguous whether the act articulates that that contempt attaches to any act which viewed independently would violate a protective order, or the mere fact that a protective order was violated, and thus the unit of prosecution is that one protective order. And at the outset, Mr. Richardson would point out that the court employs the rule of lenity when there is some lack of clarity, and this isn't a high bar. And that comes from Hurd, Jones, and Sanders, which quotes Nixon, which applies the rule of lenity when the DC Council has not clearly or unequivocally stated its intent with respect to a criminal statute. And here, the words of the statute read that violation of a protective order is chargeable as contempt. It does not state, for example, that every violation, a violation, any violation, or each violation gives rise to contempt. And so that on its face is ambiguous. And I would point the court to both Bell and Sanders. And in Bell, the court found that there was ambiguity with respect to the Mann Act, where the statute there criminalized the transportation of any woman or girl for immoral purposes. And the court found that this was ambiguous as to whether the act criminalized the act of transporting or the number of women and girls transported. And because it was ambiguous, the court applied the rule of lenity there. Conversely, in Sanders, this court found that a statute was not ambiguous when it referred to an offense or the felony with respect to a sentence enhancement statute. And I think that the statute here, DC Code 16-1005F, is more akin to the language in Bell than in Sanders due to the absence of an article or qualifier. And I would also—
Let me, I hate to interrupt, but let us hear from the government now, and we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
Counsel, Ms. Tan.
Good morning, and may it please the court. Caroline Tan for the District of Columbia. Starting with the double jeopardy issue, there's more than enough evidence for this court to recognize that Mr. Richardson reached a fork in the road, had time to reflect on his actions and retreat, but decided instead to inflict a new outrage. Between each message,
I'm sorry to interrupt, Ms. Tan, but what about appellant's argument that we're in the digital space here? It's just different than the physical space is what I understand appellant to be arguing, right? And so you can have these kind of continuous, unbounded by time conversations that are ongoing in a way that you wouldn't say on the telephone, because you're talking on the phone and then you hang up the phone and then you call back, or, you know, in a correspondence by letter where, as I described it before, you write a letter, you put it in the envelope and you mail it. And then if you want to say something else, you write another letter. Here, you know, you just have this unending stream. What about that argument?
Sure, Your Honor. I have two responses. The first is it's certainly possible in digital space to have this back and forth interaction, but we think the record is pretty clear that in this case, that's not what happened. We have one block of messages from 2:09, another block that comes at 3:39. Ms. Hargrove never responds to any of these. Another at 7:50 and then another at, I think, 9:30. So even if that's possible in the digital space, that's not what the record reflects in this case. Secondly, this court has said in Gray, for example, that that assessing multiplicity arguments needs to come from the defendant's point of view. So we don't think the digital space should really be different in that sense. We still look at whether there's a fork in the road from the defendant's point of view. And so whether or not he's dropping a letter in the mail or sending a text from his phone, he always has that same ability to stop and reflect on his actions. What
if the evidence were this? What if Mr. Richardson says, look, I like to choose my words carefully, very deliberate. And so I sent a message at 2:09, and then I sat at my computer and I thought about my next message for an hour and a half. Now, given what that next message was, I doubt it. But let's just say he's very contemplative. In that instance, would that kind of evidence be enough to escape a second conviction? I didn't do anything else. I didn't make a sandwich. I didn't go watch a movie. What I did is I sat and I thought carefully about my next statement.
We do not think that would turn two messages into one act. Essentially, we think Spain is a very helpful case in that regard. That was a case where the defendant had just intervening minutes to think between the two acts. The first was luring the victim to take off her pants, and the second was luring her back into bed after she had gotten out. And despite the fact that the defendant maybe only had a couple minutes to think about what he wanted to do next, this court recognized that those were two separate acts. So I think even if the defendant had just taken 1.5 hours to think what his next message would be, that provides more than enough of an opportunity for him to have reached a fork in the road and decided whether or not he wanted to retreat.
But, sorry to go ahead on Judge Deals. I mean, what if the thoughts were less than an hour and a half? What if it was half an hour between messages? Like where's the government's line here? Sometimes these messages, my experience with these messages is that no one wants to make them too long. So you get very short bursts of messages that carry on from one to the next to the next. So what if it's, 5 minutes between messages? Are those individual acts in your view?
So 2 responses, Your Honor. Certainly, if there were just 5 minutes, that would be a much stronger case for why that might just be one count, and perhaps the government would charge that as just one count. We do think that case law Spain, for example, supports the fact that intervening minutes can still be enough for these acts to be separate. But it's a very factual inquiry. That's something this court recognized in Cullen. It's highly fact intensive. So it would really depend on—
I'm asking what are the boundaries that a court should apply? Or are you just saying just leave it to prosecutorial discretion?
We think that the fork in the road test indicates it's a very fact-intensive inquiry, and it's hard to draw a bright line that'll apply to every case. I mean, in this case, for example, if the government had charged the first 5 sentences of Mr. Richardson's Facebook message as separate counts, we think that would be a strong argument for saying those counts should merge, because that was clearly part of a continuous stream of texts.
You think that would be a strong argument? You don't even give me ironclad argument that sending a single message is not more than one contact?
That would be extremely strong. We think,
right.
Yes. I mean, yes, that would be one count. That would be much more akin to a succession of physical blows.
I mean, it sounds more akin to me to be a single blow of many sentences, but to mix metaphors a little bit.
Yeah.
But fair enough.
Sure. So the fact—
Can I get your reaction to, and I'm sorry if I'm derailing you a little bit. Would your answer be any different if the evidence were clear that Ms. Hargrove received these messages all at once?
You mean she didn't—
As in, some might say that you can't have contact without it being received. I have not successfully contacted somebody by putting a letter in a mail. I have successfully contacted them when they've received that letter. And so if all these messages are received at one point, one might think that is a single contact, even though the sort of initiating acts took place on four separate moments in time. They were culminated at once so that we have a single contact here. What's your reaction to that?
My reaction is that how the victim experienced the messages is probably not relevant. This court said in Gray that we look at the fork in the road test from the defendant's point of view and what the defendant was thinking and whether the defendant had an opportunity to retreat. So whether Ms. Hargrove either received them all at once because there was a delay within Facebook systems, or viewed them all at once, or viewed them separately, we think is not relevant to the inquiry.
See, that's interesting to me, because to me, the offense has just not occurred on the first, second, third, or fourth instance. There is no offense until contact is made. So let me just tweak my example a little. He sends 4 messages to the wrong Facebook account. He tries to send them to Ms. Hargrove, and he sends them to Ms. Hargrove, so he never makes contact. Has he committed 4 offenses?
No, he hasn't contacted Ms. Hargrove.
And so in my prior hypothetical, why do you think he made 4 contacts when they were all received at once?
So to clarify, Your Honor, are they received at once because Facebook had a delay and so they didn't go through to her account until the same time? Or when you say received, do you mean she read them all at once?
I actually don't. I don't mean it in one way or the other. They don't strike me as different, but pick which one you like, or tell me why they're different in your view. Either there's a delay in the system in sending them to her inbox, or she checks her Facebook once a day. And would it matter if he knew she only checked her Facebook once a day? But that's a follow-up. You could start with the first part.
Sure, Your Honor. Generally, our position is it doesn't matter how Ms. Hargrove viewed the messages. So to start, I suppose, with your second question, whether she views them all at once, that shouldn't be the inquiry. And, looking at Spain, once again, the court didn't think, does the victim experience the sexual assault once or twice? Is it all one continuing act for her, or is it separate? It's really the defendant's state of mind that the court is trying to interrogate and is trying to think.
That's a poor analogy, I think, because in that instance, the victim is experiencing the sexual assault. But Judge Deal's point is, until the victim in this case actually reads the message, there's no contact, right? It's like the envelope in the mailbox that no one has gone to the mailbox to see if it's there, right? So if the complainant in this case only checks Facebook on her phone and her phone is off, and all of these messages come in, and then her phone is misplaced or stolen such that she never turns on her phone to see these messages, is there any criminal act at all? Not are there 4 versus 1, but is there 0 versus 4?
So, Your Honor, I think as long as the messages reached her Facebook account, that's a contact. Because she can always,
even if she never checks her Facebook account.
So 2 responses. The first, I think yes. Well, yes, even if she never checks it, because the message has gone through, it's there. And at least in this case, the parties met on Facebook. They did communicate on Facebook. So separate from sort of the theoretical question of whether it would apply if she never checked Facebook, that's certainly not the facts of this case. If you look at the TPO language, it says that the respondent shall not contact petitioner in any manner, including but not limited to, and then social media is one of them. That really puts the onus on the respondent to not reach out to Ms. Hargrove. It doesn't really say anything about whether or not it matters that she checks her social media regularly. It's sort of just taken as a given that it's on Mr. Richardson to control his impulses, I suppose. And in this case, I just want to emphasize these parties did have a regular relationship on Facebook. That's how they met. And so there's certainly no evidence in this record that Ms. Hargrove doesn't check Facebook or that he knows that she would never check.
Now, moving to the Interfamily Offenses Act argument a little bit, what if the TPO here said, do not utter or communicate a single word to Ms. Hargrove? Do you think if that were the order that we were dealing with, that his first message would be, I don't know how many words are in it, let's call it 75. 75 different offenses because he was not to utter one, but he uttered 75 times he broke that, he violated that order by uttering 75 words. Do you think that's a plausible reading of that hypothetical order?
Your Honor, I think the government would look to the fork in the road test again and see whether it looks like all 75 words were based on a new impulse or if they were part of a string of sentences based on one.
Yeah, that was probably not a good question to get at the Family Offenses Act argument. Where I take it, the argument is just, look, as an act, we're trying to prevent people from, from violating these protective orders. It's not so clear if the purposes of that act are being served by multiple, finding multiple violations for contexts that all occur on the same day, without any intervention, without anybody saying, hey, no, you can't do that. And I do, it feels like a lot that, if you had sent these all at once, you'd say that's one offense, but the divvying up of time is enough to make it 4 contempts. I'm not sure that's what was intended under the Family Offenses Act. Do you think it was?
Yes, Your Honor, 2 responses. The first is we don't think the legislator could have intended, but a somewhat absurd result that the government has to charge a defendant who calls you once the same as somebody who comes to your house every day, for example, and screams outside your window. Even though the statute doesn't necessarily explicitly say more than one violation will lead to more than 1 counts of contempt, we think that the defendant's reading would lead to a somewhat absurd result that couldn't have been intended for an act whose purpose was to counteract the abuse of women, which this court has recognized should be construed liberally. Second, we think assault is a helpful analogy. If Ms. Hargrove had been shot in the foot, for example, in the right foot specifically, on the same timetable as she received the messages here, we don't think anyone would say the government couldn't charge that as 4 separate counts of assault, even though the DC assault statute doesn't explicitly say multiple attacks could open you up to multiple counts of assault. And we think, double jeopardy jurisprudence really does take as a given that multiple violations can lead to multiple punishments. This court has also recognized in Brown that multiple punishments for multiple violations of the same statute is okay. So as far as the Intra-Family Offenses Act argument goes, we think that it would lead to somewhat absurd results and can't have been what the legislator intended. And
could you just remind me what the sentencing discretion is like for an act of contempt under the act? Is there what the bounds of permissible sentences are? Because that might affect whether or not I think it's absurd.
I can only really speak for the sentence in this case and what happened in the sentencing hearing here.
Concurrent 180-day sentences suspended, yes. Right? Am I getting that right?
That's correct. Yeah, suspended us to all but 45 days, and then more or less. And
of course, if the court's sentencing authority on an order of contempt is unbounded, I have no idea what the answer to. I should check. If it's unbounded, then there's really nothing absurd about it being a single act. You could account for all of it in sentencing and how severe the contempt is viewed to be.
I know that typically the sentences tend to run concurrently, but I'm afraid I'd have to follow up with the court if the court would like on.
I was just curious.
Yeah.
I can figure it out.
Just one more point, Your Honor, on that, if I may.
Go ahead.
Thank you. Just wanted to flag again that this court has regularly upheld multiple convictions based on 1 TPO and 1 CPO. The briefs highlight Shirley and Dixon, but there are numerous other cases where this court has upheld that notion and hadn't had an issue with it necessarily. So adopting the defendant's reading would be a sea change in TPO law.
Counsel, thank you.
Thank you.
Ms. Kimball, we'll hear you for a few minutes.
Thank you, Your Honor. I'd like to pick up with that last point regarding Shirley and Dixon and point out that in neither of those cases did the court address this specific issue. And this question of how to interpret the Inter-Family Offenses Act is indeed an issue of first impression before this court. For example, in Dixon, the appellant there was only convicted of one count. And so the facts there, despite what the government may contend, did not lend itself to analyzing whether multiple convictions may properly flow from the violation of the same TPO multiple times. And the court there, in fact, reached its decision entirely beyond any consideration of this issue. And the same is true in Shirley. There, the issues were not raised before this court, and so the court has not ever addressed the issue before it today. I'd also like to point out that
Ms. Kimball, could I ask you a
Yes.
perhaps unfair question? And what is Mr. Richardson's interest in pursuing this appeal? This has not been raised in the briefs. And normally criminal convictions, even when a sentence has been served, there are collateral consequences so that the appeal can proceed. I'm not sure if that's true. It might be, it probably is. I'm not sure what the consequences of having 4 contempt convictions as opposed to 1, whether or not that does have any collateral effects that might, give rise to this being something other than a purely academic question.
Yes, my understanding is that due to the collateral consequences that flow from multiple convictions, Mr. Richardson has an interest in only having one conviction. And that's under both the statutory and the constitutional question. And then, of course, under the constitutional question, we have the interest in, there not being a violation of his constitutional rights. And I'd like to also point to the motivating policies of the Inter-Family Offenses Act. This court in both Ramirez and in Cruz Foster stated that the act should be construed in furtherance of a remedial interpretation rather than a punitive one. And multiple convictions here serve only punitive purposes. For example, with 1 conviction or 4, Mr. Richardson, as stated, served the same sentence. He has the same terms of supervised release. He attends the same domestic violence intervention courses, and he goes to the same required counseling. So I would argue that that already serves the remedial purposes here. And just one last thing on the double jeopardy issue. I'd like to point out and perhaps give an analogy to the court with respect to what constitutes a continuing course of conduct in online messaging. So perhaps if 2 people are making dinner plans and at 9 a.m. someone suggests they go to Mexican, and then a few hours later says, actually, let's go to Thai. And then a few hours later says, I'm really busy, let's just get drinks. And then finally ends up canceling. Those, even if all received within the same time frame as Mr. Richardson's messages here, I think would fairly be held to be the same course of conduct. And I think that illustrates the double jeopardy clause issue well. And I see that my time is up. So if the court has no further questions, Richardson asks that the court reverse the convictions based on the Drew arguments, or alternatively remands to the lower court with instructions to vacate 3 counts and resentence him accordingly. Thank you.
Counsel, thank you both very much. The case is now submitted, and the 2 of you may log off. Well, the second case on the calendar, First American Title Insurance Company versus Pacific Western Bank. Council, good morning.
Morning.
Mr. Russo, you may proceed.
May it please the court. Your Honor, I represent First American Title Insurance Company, the assignee of GPI, who was the purchaser at tax sale. Or I'm sorry, the purchaser of the deed from the tax sale purchaser. Your Honor, what I'd like to focus on in this argument is the distinction or the implications of applying what the appellee refers to as the commercial law to the real property law and the implications on the District of Columbia real property law of that implication, of that application. Here, it is undisputed that the FBO entity, Capital Source Bank, FBO Aon Financial LLC, is a fictitious entity. It did not exist under any jurisdictional creation. Question is, with respect to DC law, if this is permitted, can a fictitious party now bid in the tax sale auction process? Can
Is that the
fictitious
question
party-
before us? That seems like a separate question. I thought the question was whether the trial judge got it right to say that First American cannot sue PacWest as the successor for Capital Source for, for the money that GPI spent to buy the house that was improperly foreclosed on, right? That First American can't sue for breach of warranty, breach of contract, unjust enrichment, and negligence, right? That's what we're looking at. So I wonder if you could explain to me why the trial court was wrong.
Well, the issue, I think all would agree that the entity who was paid the money, who entered into the contract, is responsible. There's no dispute there.
Let's just walk me through. When you say the contract, which contract are you referring to?
The contract of sale of the property from the FBO entity to GPI.
Okay.
And in that FBO entity, the question is, who is the real party behind that FBO entity? Is that real party Capital Source Bank? Is that real party Aon Financial?
And why don't we have a factual finding that that party is Aon Financial?
Why don't we have a factual finding?
Yeah, I thought we have a factual finding, say, well, in fact, who's pulling these strings and the party that's responsible for this is Aon, not Capital Source or PacWest, no matter what was written on the title.
Well, the factual findings go towards the partnership and joint venture connection. But my point is, with respect to the FBO designation, the appellee contends that it is the naming convention under commercial law that says when you name somebody as an FBO,
what did the trial court say about who the FBO was?
The trial court was silent as to that issue, as was the appellee below.
I thought the trial court said in a footnote, well, I mean, on the first page of the trial court's order, the trial court says that Aon was the winning bidder of the tax certificate. Now, in fact, I think the record materials say that it's FBO, but maybe what the court is implicitly saying is Aon is FBO. And then the court says on the first page of the order, Aon sold the property to GPI. Once again, the record materials indicate that FBO's name is on the contract for sale. But maybe what the court is saying is that Aon is FBO. And then we have footnote 2 on page 5 of the order, where the court says FBO Aon is a naming convention that just shows it's designed to protect PacWest's security interest in Aon's tax lien receivables, right? So in this context, any and all actions in the name of Capital Source FBO Aon appear to refer to Aon, as a distinct entity, right? It seems to be the court saying Aon is FBO, FBO is Aon. Am I wrong about that?
The court is saying that it's our contention that as a matter of law, the court was incorrect.
Okay,
United
so
States
stop right there
doesn't-
because I just want to make sure where we are. You just said as a matter of law, the court is incorrect. So we've got a legal question about what the FBO entity is, not a factual question. Is that your argument? Because your standard of review seems to be pointing us to clear errors of fact, but I'm trying to figure out whether you're asking us to review a legal error or a factual error.
I believe it's the legal error. Well, there are legal, factual, and legal issues involved. With respect to the FBO question,
Are there really any disputes but put aside who is FBO, are there really any disputes about facts, right? Like we have the loan agreement, we have the contract for sale, we have all these documents, right? Are there really, the question is what to make of all of these facts, right? Is that a fair encapsulation of what we're confronted with?
The question is how to apply these facts to applicable law.
Okay, so why do you think the court got it wrong to say that FBO is Aon and Aon is FBO?
Your Honor, looking to the Securities Exchange Commission versus Credit Corp, the United States District Court for the Southern District of New York analyzed what it means under the commercial law to have an FBO designation. And what that court said in short was it's the first party that is the responsible party.
I think you're misreading that case because I think what the court was saying was it was looking at who an entitlement holder is, right? And if you go to the New York's version of the UCC, an entitlement holder is defined as a person identified in the records of a security intermediary as the person having a security entitlement against the security intermediary. So it's someone with a security interest. It is not someone with an ownership interest. And so all the SEC versus Bancorp case said was that in that case, CBL had the security interest. And I think that supports First American, not you.
Well, I am First American.
I'm sorry. I think that supports PacWest, not First American.
What I believe,
because I think your argument, if I'm understanding it correctly, is that you want to say that PacWest was really the owner of this asset. And
yes. What
PacWest is saying is we weren't the owner, we just had a security interest in this asset. And that seems to be what SEC versus Bancorp, which is it's a trial court decision from a different jurisdiction, so it's not binding on us, but it seems to support PacWest's argument.
Your Honor, what it said in reference to that 8-107D, the section that the court cited to, what the court said in recognizing what commercial law is that while the UCC does not include any specific provisions defining FBO, it does include a provision that assumes that ordinary practice in the securities industry would be to treat CBL, in that case the bank, and not the FBO customers as the entitlement holder. What it says is that the only language...
I'm sorry, but I just read you what the definition of an entitlement holder is. An entitlement holder is someone with a security interest.
And what it means, what I believe the court means in reaching the conclusion that it's the first party who is the FBO, is that the only language in the UCC that addresses something similar to this is 8-107D, which says you look to the party that is the first party in that FBO relationship.
I think we're talking past each other. Besides that case, do you have anything else to tell me why you think the court got it wrong to say that Aon is FBO and FBO is Aon?
The court, as a naming convention, and as the court in the city of Cleveland noted, a naming convention is supposedly what the parties agree it to be. And as the court in Cleveland, dealing with the same facts, said, it is what the parties agree it to be, and with the lack of legal context, it is what the evidence shows it to be. And it is not the opinion of one bank executive as to what it means.
Would
So
it be,
I'm
may I
going
ask, I'm sorry,
I'm
go
just
ahead.
going to disagree with you with the understanding of what the City of Cleveland case stands for too. Because the City of Cleveland case, at least the appellate decision, said in the end, we don't need to reach what Pac West's argument about what the FBO designation means, right? What they said is, we have this nuisance law that requires owners to be held liable for owners, and that owner is defined extremely broadly to include people who have a legal or equitable interest in the property. And so even under Pac West's argument that they're just a lender with a secured interest in the property, they're an owner under Ohio nuisance law. So I don't understand how that gets you anywhere in this case, because we're not applying Ohio nuisance law.
The value of that case is the decision that the FBO entity is the owner, and the contention that the definition of ownership is extremely expansive, I'd respectfully suggest is not accurate. In the District of Columbia, with respect to tax issues, under 47-802, an owner is defined as the owner of record of real property, and for the purpose of appealing assessment, the tax sale purchaser. In this case, if this case goes forward as it is, the owner of record is Capital Source Bank, FBO Aon Financial LLC. That is the same owner here. You don't need to get into all the other definitions of what an owner might be under the Ohio statute. You have the definition, you have the same definition of owner. Record
So never
owner
mind
is record owner.
mind about the Ohio case. That isn't relevant. We should just look at DC law.
Well, what I'm saying is the Ohio case provides a logic that I think should be applied here in the absence of any law in the District of Columbia on the issue of what an FBO is, or what the implications of this interpretation would be on real estate law in the District of Columbia. And Your Honor, I do apologize. At the beginning of this argument, I specifically did not reserve time. I'd like to make sure I reserve 2 minutes for rebuttal at the end of this argument.
That's okay. Before you sit, that's okay. Before you sit down, may I ask you the following question? Would it be correct to frame your argument or position as follows? What the designation Capital Source Bank, FBO, Aon LLC conveys is that, as far as the property is concerned, is that Aon has the equitable interest in the property, but that the legal holder of the property or title to the property is in Capital Source Bank. And is that in a nutshell what your position is? That it doesn't, in other words, that it doesn't simply convey that Capital Source Bank has a security interest that it needs to protect in this property. Have I stated your position correctly?
Respectfully, Your Honor, I don't think so, because to do that would be to recognize the separation between equitable title and legal title. And in effect, that is what a deed of trust does under the District of Columbia law. What we're saying is that record title is in the bank, and for the same reasons as concluded by the Securities Exchange Commission and in the Collins case, the FBO Aon indicates for the benefit of, or is there for the use of the bank and how it's holding its account. In the Collins case, it was the suggestion of the bank president to hold it like that so that the bank would know what account it's dealing with. But it is the owner of this property, and the record owner of this property in the district is Capital Source Bank. Otherwise, you would have a fictitious owner being record owner of property, and that's not consistent with the law in the district.
I'm not sure what your answer is, and this will be my last question. Could the parties to this transaction buck the convention? That is, let's say there were clear evidence that Capital Source Bank wasn't even involved in this transaction. Aon didn't even inform them about it, but they said, well, we're gonna say Capital Source Bank, maybe to insulate themselves from later suit. But there is no question that it was always Aon acting. Capital Source Bank had nothing to do with it, and they just invoked this naming convention, contrary to any intention to give any ownership interest to Capital Source Bank. Would the convention override the party's intention about who is the owner of the property? The convention, as you put it, that when one party has something for the benefit of the other, it is that initial party that has the ownership interest. I'm not sure does that question make sense?
It makes sense. And the problem there is often we have title taken in uncertain names or wrong names. And in those cases, we have to file a quiet title action to get to the bottom of who the proper party is. If we were to interpret it or explain it as Your Honor has laid it out, we are creating yet another uncertainty in record title.
So sure, it's an uncertainty. I mean, I guess that just sounds like a factual uncertainty to me, and the trial court could say whatever the convention. And I'm not so sure the trial court didn't say whatever the convention. Maybe this would ordinarily indicate that Capital Source / PacWest is the owner, but here on the facts, there's just no question that was not what the parties meant by this notation, and really, your client doesn't get to upend their expectations in who they had the actual ownership interest. What's wrong with looking at it that way?
Because their loan agreement puts them in a position far superior to that of a lender. It puts them in control. It gives them title to the right title and access, gives them control of the property, gives them control. It says the property shall be co-titled in the name of the FBO. How can you co-title, co-owner, but not be an owner?
Actually, I kind of asked a hypothetical, removing some of those facts, but it sounds like it sounds like you think it is fact dependent. It is not an ironclad custom that would, upset parties' contrary intentions if they were. In fact,
there is no evidence in this record
I understand
that it is as the PacWest would have it. Thank you.
Okay, Mr. Russo, thank you. Let us hear from counsel for PacWest, and we'll give you a few minutes in rebuttal. Counsel.
May it please the court, I am Stephen Leitis. I represent Pacific Western Bank, successor by merger to Capital Source Bank. Capital Source was the original entity that contracted with Aon Financial LLC to provide financing under a $30 million revolving credit loan facility that allowed Aon to operate its business, which was the investment in real estate opportunities.
Mr. Leitis, so I didn't see a response at all in your brief to First American's argument that these two cases, the Bancorp case and the Collins case, stand for the proposition that there's a naming convention under the UCC, that if you have name FBO entity, that the first name is the actual owner of the asset. Do you have a response to that?
Yes, I do, Your Honor. The response would be to look at the UCC itself. The definitions, the general definition.
You don't want to talk about those cases?
Well, Collins, sure, we can talk about Collins, but I wanted to direct the court, right to the answer. The Collins case, the facts are completely different. It is unrelated to commercial financing. The Collins case was decided under UCC Article 4 and has no application to this. To this case, similarly, we were talking, or Mr. Russo and the court were talking earlier about the Credit Bancorp case. which is a case decided under, and Your Honor asked questions directly to Mr. Russo about it. This was a case decided under UCC Article 8, the securities section of the Uniform Commercial Code. The facts in that case are that it was a Ponzi scheme, completely unrelated to commercial finance transaction, and there is a specific statute in UCC Article 8, or provision in UCC Article 8 that talked about for the benefit of securities being held for the benefit of others. The answer to the question, as is often the case in Uniform Commercial Code matters, can be found in the code itself. And if we take a look at the definitions, the general definitions section of the UCC, which is section 1-201A, we read that unless the context otherwise requires, words or phrases defined in this section or in the additional definitions contained in other articles of the UCC that apply to particular articles or parts thereof have the meaning stated. If we take a look at the official comment to the UCC, this was a new provision added to the UCC several years ago at this point, not a new provision anymore, but that provides the court with guidance that simply because one section of the UCC uses a term of art doesn't mean that when that term of art is used elsewhere, that the term of art has the same meaning as is required in the original, in the section where it's dug up. We're dealing with Article 9 of the UCC. This is a commercial finance transaction. It's not a securities case. It's not a Ponzi scheme. And it's not a case under Article 4. It's a case under Article 9. For the benefit of is not defined in Article 9. So where do we go then to find out what it means? We go to the only place that has any evidence of that, and that's the party's intent, which is the 122-page commercial loan agreement that is Exhibit 3 in the record, in the trial record. And that is where the parties agree that Aon will only acquire these tax certificates using the FBO designation. Mr. Russo several times referred to a fictitious entity or what have you. It's not an entity. It is a naming designation. We did a nationwide search. It doesn't exist. It's not an entity. It is a naming convention, and it ends with an LLC because Aon's name ends with an LLC. So the reason for Capital Source's name appearing on those certificates was because tax certificates, unlike Motor Vehicle Administration, titles for automobiles, do not have a place for an endorsement in favor of a secured lender where its security interest can be noted and advertised to the world. If Aon took title to this tax certificate in its own name alone, and there was no designation on this essentially bearer paper that it was subject to the security interest of a bank, Aon could sell it to someone else who didn't have any idea that there was a lien, free and clear of the claim of the bank, leaving the bank having its only remedy to sue Aon for the recovery. We refer to that as sale out of trust.
Mr. Leititz, I follow that argument, and I understand the need for some sort of designation to protect the bank's security interest. The question I want to ask you is this. As you say, there is no settled normative meaning of FBO. And so you direct us to the parties' agreement to understand what for the benefit of means in this transaction. Now, of course, the person or entity, in this case, what was it called, GPI, was not privy to that loan agreement, as I understand it, and only knows what it sees when somebody comes to it and says that Capital Source Bank, for the benefit of Aon LLC, wants to sell you or is willing to sell you this tax certificate. And the thought that I wonder about is it struck me that, and I'm not saying anyone was misled. This is not a question of misleading or fraud or anything of the sort. What I'm thinking is that, well, this is being done, of course, with Capital Source Bank's full consent and indeed direction, as you say. And the natural reading of that phrase is not that there's a single entity, as you say, it's the LLC relates to Aon, but that this sale is being conducted by Capital Source Bank, that it is the holder of this deed, it is the title, and it's making a record that it's holding it for the benefit of Aon, but the seller is Capital Source Bank. And it's the seller, Capital Source Bank, who's making the representations in the sale agreement for, of good title and so on and so forth. And it is the seller that, in effect, is on the hook if there's a breach of contract or is responsible for the performance of that contract. If all that is correct, I'm wondering why that doesn't make, it would be different if this were being done without Capital Source's approval or knowledge, but that's not the case here. If what I've described is correct, I'm wondering why there isn't a straightforward breach of contract liability for Capital Source Bank. And this was something I got at, perhaps inartfully, when I asked Mr. Russo whether the reading of whether what that designation conveyed was that Capital Source Bank was the legal owner, title holder, and Aon had the equitable interest. Maybe that wasn't the best way to put it, but I think you see what I'm asking. I hope.
I certainly do, but if I may, and I feel very, reluctant to say that pretty much all of the facts that Your Honor just recited are not the facts in the record. The fact in the record is that the deed went from Aon Financial LLC to GPI. Capital Source Bank was not mentioned in it, was not, and took.
I appreciate that, although it is interesting that Capital Source Bank provided a quitclaim deed.
The quitclaim deed did not convey equity. The cross-examination of Deborah Acero that I conducted during the trial, Your Honor, Ms. Acero acknowledged that the quitclaim deed did not mention equity or fee interest or ownership at all. What the quitclaim deed accomplished was to release the security interest in the property. The words "any interest it may have whatsoever" are included in the quitclaim deed, but fee is not included, and ownership is not included, and equity is not included. They are specifically excluded because we're only dealing with a security interest.
They weren't specifically
similar to the contract. I'm sorry.
Excuse me 1 second. They weren't specifically excluded.
Oh,
Right. I mean,
yes,
the language is pretty expansive. If it's any interest, it could include them.
I mean,
Well,
and for that matter, it didn't mention security interest specifically.
Right, but it also did not say that they were releasing a fee interest because there is no fee interest. Capital Source Bank is not on the contract of sale, which is something else that Your Honor described. Aon is on the contract of sale. In fact, it was GPI's title insurance broker, Capital Title, that I believe, acting on instructions from First American, required that a quitclaim deed be provided.
I'm sorry, did you just say that Aon was on the contract for sale? I thought FBO was on the contract for sale.
I would have to, I could be wrong, Your Honor, but
I'm looking at the appendix on page 413.
Okay, I misspoke because the legal effect of the contract of sale follows from the determination by the court that the FBO is Aon Financial LLC. It is not Capital Source Bank. The same thing applied in the Weldon-Sollers litigation that was in the Court of Special Appeals in Maryland. That opinion was not disclosed to the court in First American's opening brief. We provided that to the court so that the court would have the benefit of the reasoning there, which is much closer, almost exactly on all fours with this matter, whereas the disputes that we were discussing earlier in Cleveland were not on all fours. Those, Your Honor, actually, Judge Easterly, you pointed out that it was an Ohio nuisance statute, not a commercial finance, not a UCC or tax certificate transaction. And there are public policy reasons for that. But here we have to look at the only evidence in the record, which is it's uncontroverted. It was admitted by stipulation, the loan and security agreement, which, you know, we could have called it a peanut butter sandwich. It would be silly, but you could call it whatever you want. The mere fact is that a naming convention was used. And Judge
Mr.
Lichtman,
Russo, sorry, go ahead and finish your answer to Judge Glickman's question.
thank you. My train got off the track there.
I apologize.
No problem. Judge Glickman, you asked me a question related to this, and I'm trying to recall it right now. That
maybe the way to get back
the GPI reliance. Why shouldn't GPI be entitled to rely on Capital Source Bank as the owner, which is factually incorrect to begin with? But the reason why is because GPI specifically testified, and this is in the record, that it didn't rely on that. It assumed that it was buying this property from a company that, owed money to a bank. It didn't believe it was buying it from Capital Source Bank, and the designee of GPI also testified that he didn't care. The GPI did not care who the seller was. That's why they had Capital Title to look into it. Capital Title then missed a number of things, didn't ask for the organizational documents for this, fictitious, this name designation, didn't go to the court file to check to see whether the return receipts from the certified mail were signed by the owners of the property. There were a whole slew of problems with the underwriting here, but GPI did not rely on Capital Source Bank's involvement at all.
Is reliance of that nature, I realize that's only a partial answer to my question, but is reliance of that nature an element of a breach of contract claim? In other words,
Goes to the, I'm sorry, go ahead.
in other words, I can understand GPI basically thinking, look, as long as we're getting the property, we really don't care about the identity of the seller and what Aon is doing with Capital Source Bank and all the rest. All we know, but I was under the impression, and maybe you are correcting me, I'm not sure, that the contract under which GPI agreed to buy and some entity agreed to sell the tax certificate was a contract signed by or on behalf of the FBO in its entirety, not simply on behalf of Aon. Am I mistaken about that?
Yes, the mistake is that nobody signed for the FBO. There is also a lot of material in the record showing that all of the people who signed papers, with the only exception being the quitclaim deed that the title company requested, are signed by people who work for the Tax Lien Law Group or for Aon Financial LLC, which Mr. Cook's testimony, as well as a number of other filings in the case, uncontrovertedly established was not Capital Source Bank. It was all.
Well, I know that those were all people. I know those were all Aon people.
Right.
I understand that.
You just said that the contract for sale was not signed. I'm sorry. Can you say that again? Because I'm looking
by an agent of Capital Source Bank. It was signed
by an agent of, but there is a line for seller Capital Source Bank FBO Aon Financial LLC, and then there is a signature underneath that for Joshua Lord.
For Mr. Lord?
Yes.
Mr. Lord is an employee of the Tax Lien Law Group of the Aon entities.
Okay, but there is a signature. I just thought you said that it was not signed by the FBO entity, and it is signed by the FBO entity. But your point is there's evidence at trial that Mr. Lord is affiliated with Aon.
Yes, he is. There's testimony to that effect, and there's also documentation to that effect. Mr. Lord, John Lord, has nothing to do with Capital Source Bank.
That simply means that by signing that, he's representing that he properly speaks for whatever Capital Source Bank, FBO, Aon, LLC means. And I'm posing to you the question of whether, to a normal reader, doesn't that mean that the bank is selling this tax certificate for the benefit of Aon? but the bank is selling the certificate. That's what I'm sort of, I don't want to say hung up on, but the question I am directing you to.
Your Honor, I don't know what the normal, reader might think of this. We have to rely on our record. To a hammer, everything looks like a nail. To a real estate insurance company or real property insurance company, everything looks like a deal for the purchase and sale of land. But this is about the business of real estate investment, and this is a capital loan. This is it's not a loan to buy this property. There's a borrowing base. Mr. Cook went into a very exhaustive, at Judge Williams' questioning, she was fascinated by it and really followed it all the way down till she understood it, how this loan and security agreement, how this revolver, as we refer to it in shorthand terms, operated. And so before we can say, and before we can call this FBO an entity or that it's signing something or that whatever, we need to understand what it is. And that requires us not to assume what it is, but to look at what the evidence of what it is. Sorry about finishing that sentence that way. But and the only evidence that we have in the record, because First American never introduced anything to the contrary, is what is included in the loan and security agreement, which also includes a right for the borrower to manage and operate its own business, including the purchase of tax certificates such as these, which is in fact exactly what they did. John Lord was an attorney who worked for Aon.
One question for you, if I may, just one follow-up. Suppose this agreement had been signed by John Lord and everything else is exactly the same, except that the name was not Capital Source Bank FBO Aon, but just plain Capital Source Bank. And suppose that Capital Source Bank has said, look, to protect our security interest, and we have this in writing with you, Aon, that's how you're going to sign these agreements. And that's how you're going to deal with this, because we want to be protected. For all those, we want our security to be protected. And it is a perfectly bona fide security agreement. But suppose it had been signed that way. Would you still be able to argue that, well, you have to understand that although it was signed with Capital Source Bank's approval and at its direction as Capital Source Bank, it was really Aon, and Capital Source Bank has no liability here. Could you make that argument under those circumstances?
Well, that is certainly an entirely different set of circumstances.
I'm not sure. That's what I'm wondering about. Because what you're telling me is that the FBO designation has no real recognized meaning in the law. It's just, it is what it is. And the only way we happen to know its meaning here is that between the two parties, Aon and Capital Source Bank, they treated it as meaning X. Well, that's nice, but the purchaser, I think, doesn't have any reason to know that. Or at least I shouldn't say doesn't have any reason to know that. That would be important if the purchaser had reason to know it. I don't know if the purchaser had reason to know that or not. It sounds like the purchaser didn't, because the purchaser said, I didn't care. What do I know? What do I care?
Well, it's important in the context of, I'm sorry, Your Honor, did you
so that's why I gave you that hypothetical.
Okay, so the reason there was testimony also taken at the trial and also included in the filings in this case with respect to how do you perfect a security interest. So the bank is not going to take title to its borrower's assets, because to do so exposes the bank to significant lender liability risks to the borrower, because then it is taking control of the borrower's business. Banks don't do that. They avoid that very much, because Your Honor may remember that some years ago there was a storm of lender liability lawsuits with improper control by lenders over the borrower's business. The banks take a hands-off approach. All they want to do is confirm that their collateral is secure, which was the purpose for this. Now, real briefly, under the UCC, we've all heard of financing statements. Well, you file the financing statement in the appropriate jurisdiction. Under Article 9, that's the jurisdiction where the borrower entity is formed, in this case, Illinois. So an all assets UCC Form 1 financing statement was filed showing Capital Source Bank as the secured party. But there's one problem with the UCC financing statement, and that is that there are a couple classes of collateral, which we have here, that the security interest will not be perfected in unless the bank takes extra steps. And the extra steps are found in Article 9. I can give you, I'm scrolling to it right now. In Article 9, which is 28 under the DC Code, 28, 9.312, 9.313, and 9.314. The only security interest in cash or intangibles of this sort is to have the possession or control. That brings us to the deposit account control agreement, the lockbox, and the manner in which the money was handled. So the FBO designation, as it is described in the loan and security agreement, is there to show possession and control of the collateral, the disposition of the collateral, to ensure that the bank doesn't have its security interest defeated and lose that collateral to satisfy the loan. Mr. Cook testified that there was a very large loss that got written off in the Aon relationship, and part of that was due to ineligible collateral. Not all of these tax certificates are eligible collateral. But to answer you directly, I'm not trying to sidestep you, Judge Glickman. The bank would not put that document in its own name. Would not take control of the borrower's business. The bank reserved the right to supervise the borrower's disposition of its collateral. That's what is provided for in the loan and security agreement. But in all instances, and the entire record in this case is quite clear on the fact that Aon operated its business independently. They didn't share any employees, any systems, any vendors, any creditors, nothing. Everything was completely independent. And the only way that the bank can do this, can provide financing in this industry, tax certificates happen because people don't pay their taxes, and the taxes are, of course, needed to build roads and repair bridges and other sorts of public benefits. So that we have this tax certificate rubric where the district can sell its right to collect the taxes to a third party, and from that sale get the taxes, and then the third party can go collect from the borrower. That's why we have this. That's why we have the tax certificate process. And the only way to provide financing for what is a very large industry is to allow the lenders who fund this and allow the district and other jurisdictions to collect taxes to do these public works, is to allow these lenders to secure their interest. Now, if like on a lien of
Mr. Lightus, can I just interrupt and say, I've got you on the tax certificates, but am I wrong to think that something changes when there's a foreclosure suit in the name where FBO acts as a plaintiff in a foreclosure suit, right? Like, I get that you can say, oh, it's just a naming convention. It's just securing our interest in the tax certificates that Aon is buying with our revolving line of $30 million of credit. Fine, right? But at some point, they foreclose on the tax certificates because the money isn't paid, and the FBO entity goes into court, which seems really odd that the FBO entity would go into court, and then the FBO entity gets title to the property, which also seems really odd that a non-existent entity would be able to act as a plaintiff in court and also get a deed of trust in a deed to a property. So does that change anything?
Think of the FBO designation not as an entity. It's everybody slips into it being an entity because there's an LLC at the end of it. It is not an entity. It is a trade.
Well, I know, but I'm trying to point out to you the reason that one slips into thinking of them as an entity is because it seems to act as an entity.
Well,
right? You don't think of a naming convention being a plaintiff, right? A plaintiff generally has to be a party.
Fictitious
and you
name.
don't think of a naming convention as holding title to something.
The loan and security agreement require, as the court is probably familiar, that the borrower do everything, official, if you will, using the naming convention to ensure that the security interest does not get defeated by the loss of possession, custody, or control. And that's what that is there for. The the only evidence that we have in the record or elsewhere in the industry, Aon previously obtained similar financing from TFC Bank, I think it was, and they used the same designation. It is a common usage. As I mentioned a moment ago, to a real estate, title company, this looks like a land transaction. The deal between, but you have to look at, why is this collateral? It's collateral because it was pledged to secure a borrowing obligation to the cash flow lender, to the bank. If the bank is not allowed or is prohibited from, or in this case, perhaps punished for having perfected its security interest by possession or control, then this industry dries up because banks won't take the risk, and then the municipalities won't have the means to sell these tax certificates and raise the funds to pay for the public works. I understand the court's questions about the outer edges of what it might mean, but what we have to rely on, the only thing that we have to rely on, is the record that shows why it was used and how it was used, and and why the industry is there. It's not an entity. I would caution Your Honor, or anybody that I talk to about this, because it's fascinating cocktail conversation. But to think of it as an entity merely because there's an LLC at the end.
That's not what gives me pause. The LLC, I grant you, seems to go with Aon's name. It's more that it's acting as an entity. And one last question about the court's order. In footnote 2, the court in its last sentence says, in this context, any and all actions in the name Capital Source FBO Aon appear to refer to Aon as a distinct entity. That can't be true for the quitclaim deed, right?
The FBO is not, I had to put my readers on to see that. I have the document in front of me.
It's page 5 of the order, footnote 2, last sentence, beginning indeed. And it simply cannot be that the FBO is Aon in the quit claim, because why would you file a quit claim, quitting any claim to yourself? Right?
It's signed by Jay Cook for the bank because the title insurance.
But it is a quit claim deed on behalf of FBO Aon, right?
Right. That's because under the loan and security agreement, Your Honor, the Aon itself doesn't have the ability to do anything to affect the bank's.
I understand what your explanation for why they did it. I'm just saying the court's order saying any and all actions in the name of Capital Source FBO Aon refer to Aon as a distinct entity. That can't be correct, right? At least as to the quit claim, that seems to be Capital Source, according to your explanation, saying, hey, we're releasing our security interest.
Well, that's a question, I think, for the title company that requested the quitclaim deed. That's
why. I think that's a question. I don't understand that answer.
The Capital Source did not require the filing, the preparation of that quitclaim deed. Anything that removes Capital Source's imprimatur of a security interest of possession or custody or control is going to defeat its interest in the collateral. So it has to approve anything that would have that effect. That's the purpose for the quitclaim deed. It's approving the release of its security interest.
Should one read that quitclaim deed as Capital Bank quitting its claim, or denying any claim?
It's whatever claim it had, which in this instance was a security interest. Yes, it is releasing its security interest so that this sale can take place. Now, Judge Easterly, I think, asked an interesting question, like what happens after the sale? Well, what happens after the sale? It's one of two things. The property either becomes real estate owned, in other words, Aon buys it in and owns it for itself in its own name, in which case the bank will put a mortgage on it to perfect its security interest in the land or in the improved property, or it goes to a third party, which is what happened here. It went to GPI, in which case the loan proceeds go into the lockbox, and pursuant to the deposit account control agreement and the loan and security agreement, the bank's interest is paid and the borrowing base, comes down, which allows for, or the borrowing base, the loan obligation is paid down, which allows for more borrowing by Aon. That's
the quit claim deed here came after the purported sale.
It came as the result of whatever the timing was, John. I don't have that in front of me, but what the timing was that the title company requested the quitclaim deed in order to ensure what it believed was a clean chain of title, and that would require the release of the security interest.
Okay, Mr. Lightis, thank you.
Thank you, Your Honor.
Mr. Russo, we will give you a few minutes, 3 minutes. You are on, Mr. Russo, you are on mute.
Sorry. When we talk about this at cocktail parties, as we've done frequently, people leave us. They don't find it interesting. But that said, what price, what cost does this interpretation have on the structure of real estate law in the district? Can it, if this is interpreted as such, a fictitious entity can hold title, that title no longer needs to be secured with a deed of trust as required by statute, and title can be released by other than, the only 3 ways to do it is a lost note affidavit, recording a note marked paid in full, or filing a certificate of satisfaction.
I don't know. I mean, there's no problem as long as everybody understands what FBO means.
And that's not understood. And what FBO means, what counsel is saying in his
Or maybe I
argument
should
is
say
that
same understanding.
what counsel is saying is that FBO is a naming convention. Everyone knows what it means, but don't listen to the Southern District when they talk about it because it's in a different section, and don't listen to the Supreme Court of Virginia when they talk about it because it's in a different section. But we all know what it means because J.T. Cook, the president of the bank, said what it means. There was an interesting point made, and that according to the UCC 912, 9312, 313, and 314, there was no way they could have secured their interest because you can only secure interest. One of those reasons is possession. Well, this happens every day. Every day when property is sold and mortgages or deeds of trust are granted, the notes underlying those deeds of trust are transferred to a custodian. The custodian holds it for the benefit of the holder of that note. That is a physical document that's kept locked up. There is no reason at all, and that document is the equivalent of possession of that note. There is no reason at all why Capital Source Bank could not have taken physical possession of those notes. Similarly, there is no reason at all why Capital Source Bank could not have taken a deed of trust of all interests in property, including after acquired interest, which by the doctrine of after acquired title would apply to property taken in subsequent to the recording of that deed of trust, much like a judgment lien. Is a judgment lien in place if it goes in place in 2010? If I buy property in 2012, that judgment lien against me applies to that after acquired property. No different here than if it was a deed of
Mr. Russo,
trust.
can I, I'm like 5 steps behind you. So just to break it down, you're saying, okay, so the bank and Aon have this borrower-lender agreement, and if Aon wants to buy tax certificates, it can go ahead and buy them, and what the bank should do to maintain their security interest in the tax certificates is take physical possession of the tax certificates.
Yes.
Okay.
That's what happens every day with notes that secure deeds of trust.
And then what?
And then the note, then the loan is funded. The note remains in possession of the custodian until the bank tells the custodian, release that certificate or that note to be further put into the stream of commerce.
Well, the business is, right, Aon buys the tax certificates, and then is trying to collect the money from the property owners on the back taxes and its, fees and costs and, whatever. That's how it makes money on this, right? So, if the bank is holding the certificate, does that impede Aon from going after the people who are in arrears on their taxes? And then what happens? You're saying
Nope.
they go ahead and they get the money and then they swap out the money for the tax certificate with the bank and release the tax certificate to the property owner and keep
As happens every day in a regular foreclosure action. In a regular foreclosure action, the trustees of the deed of trust prosecute the foreclosure action, and the note is held by a custodian. Now, sometimes, particularly 5 or 6 years ago, we're having a lot of people saying, prove to me you're holding the note. So the custodian would have to bring the note into court, and we'd hold up an original note, and the other side would get to look at it and say, okay, they have possession of the original note, because that note was, as Mr. Lightis referred to it, bearer paper. So yes, it happens all the time. This is the structure of our regular foreclosure and our judicial foreclosure process. So the idea that we couldn't do it because it wasn't like a motor vehicle title, doesn't have a place for us to put our name. It's not like a motor vehicle title. It's like a note. We could have taken possession of it. We could have filed a deed of trust in the records. We could have done many things that are consistent with real estate law. And once you do something that's consistent
But this isn't real estate. These are tax certificates, right? It's not real estate yet, right? It becomes real estate once they foreclose, but I'm still on the tax certificate part of it.
Okay. The tax certificate, the bid is made, the city issues the tax certificate to the winning bidder. The winning bidder would then, as per its requirements with his lender, hand physical possession of that tax certificate to a custodian. It could be to Mr. Lightis's office. He keeps it in a file box in his trust. Then the purchaser goes ahead and prosecutes the foreclosure of the right of redemption case as the holder of that note. And if the court says, or the other side says, prove to me you're the holder, he calls the bank and says, send your custodian down with the physical note. And the custodian comes down and says, I'm the custodian. Here's the physical note I'm holding for the buyer and the lender.
I have no doubt that happens, but that sounds like a lot of work. And why couldn't they do it this shorthand way, the way that they did it?
Because, as Mr. Lightis noted, banks that overreach get themselves into control of borrower business problems. Now, I don't know why, but this bank, they were found liable for controlling their borrower's business. That's what this agreement does. It controls the borrower's business. I don't know why, perhaps because the agreement was written in 2009 and this deluge of lender liability cases came down afterwards or hadn't fully matured, but this agreement controls the borrower's business. It is lender liability.
Okay, so that's what it comes down for you, is how we look at the loan agreement. And if we agree with you that it controls the borrower's business, you win. And if we disagree with you, then PacWest wins.
Well, both controls the borrower's business and would be interpreted pursuant to DC real estate law, because if you say that a commercial structure can control who the record owner is in the recorder of deeds, then you're setting DC real estate law on its head. How does the recorder of deeds, how does the city, how does buyers or lenders, how do they know who the record owner really is? They get this deed of trust, this quitclaim deed from a bank who says, I am quitclaiming all interest to this fictitious entity's property. Well, if that's the case, when did the fictitious entity ever deed this property away?
I mean, it just seems like you're talking about a whole series of kind of different claims. And from from a buyer's perspective, I get the quit claim that says, oh, the fictitious entity doesn't have an interest in this property anymore that I just bought. I'm thinking, well, good. That makes
from a
life
public policy perspective,
a little bit simpler. Now I know that I own the property and I'm going to move on.
how can you know you own the property, Your Honor? Because the fictitious entity never signed it over to you, according to Mr. Lightus. The quitclaim deed, all the quitclaim deed did was release his client's interest. There has never been, according to Mr. Lightus, a transfer from the FBO to GPI.
I'm not sure that's what Mr. Lightus is saying. I mean, he's not denying that there's a sales contract.
Well, the sales contract means equitable titles converted, but there's never been the transfer of legal title. That is a breach. That is a break in the chain of title of record. And that's intolerable for the steady flow of real estate business in the District of Columbia. It might make sense for a multinational bank, a multi-jurisdictional bank making $3 million loans, but the district can't be victim to that structure, because that's the way the big boys always do it. This is its unintended consequences in the district are structural. They're fundamental.
Mr. Russo, thank you.
Thank you.
I think I regret to say this cocktail party has been very interesting, but I regret to say we have to bring it to a close. I will thank both counsel for their very interesting arguments. The case is now submitted, and the two of you may log off.
Thank you.
We will call the third case on the calendar, RR Ventures LLC versus WCP Fund I LLC. Counsel, good morning.
Good morning.
Your Honor, good morning.
Ms. Johnson, you may proceed.
Yes, Your Honor. I was trying to place my virtual background on, and it's.
Oh, okay.
I apologize. It's not cooperating with me at the moment.
Well, Ms. Johnson, if necessary, we can ignore the background and listen to you.
Thank you, Your Honor. So I am Lucretia Johnson on behalf of the appellant RR Ventures. We are here today to determine three questions. One is whether or not the trial court erred in denying appellant's request for a temporary restraining order or injunctive release. The second is whether or not the trial court erred in ruling that the appellee did not have to exercise its right to foreclose before March 11, 2020 in order to comply with DC Code 42-3191.01, also known as the COVID Mortgage Relief Act. And the third is whether or not the confessed judgment was the equivalent of exercising the right to foreclose prior to March 11, 2020. I am going to stand on the arguments of my brief for the first question unless Your Honors has any specific questions. And I'm going to go directly into the second question. Here, the appellate is in clear violation of the Debtor Mortgage Relief Act. The temporary act stated and outlined in our brief that the mortgager must make available a deferment application. After our initial appearance, the law became clear because at the time of our initial appearance in the trial court, it was the temporary law in place. After that time, the more permanent law was passed and enacted for the COVID-19 relief. At that time, it was clear that the intent of the law was to prevent exactly from what happened here. It was to prevent the appellee and financial institutions from foreclosing on properties. The appellee continued to foreclose on properties, and in such case, the federal court just recently decided, the DC Federal Court of Bankruptcy just recently decided in January 14th in ETS of Washington LLC that the debtor in that case had the right to proceed with the claim that the appellee, it was the same appellee that we have here, that had the right to proceed with private causes of actions for their failure to comply with 42-3191.
By the way, is that a case you cited in your brief?
No, Your Honor. The briefs were due in this particular case.
Could you give us the cite to that case? Could you please give us the citation to that case?
Yes, Your Honor. It is, the case is in re ETS of Washington LLC, and I can give you the exact case number as well. The case number is 20-00397-ELG.
And what court was that in?
It was the United States Bankruptcy Court for the District of Columbia.
Thank you. In this case, when was the first time that RR Ventures requested relief under the Act?
The first time was the client itself requested relief via an email prior to.
As far as what the record shows.
The record shows that relief was requested in July of 2020 prior to the filing of the action.
I have the impression, correct me if I am mistaken, that the first time the relief was requested was in a letter dated July 17th, 2020, from you to Russell Drazen, or Drazen. I apologize if I mispronounced that. Is that, am I correct about that?
Yes, that's the correct time according to the record.
Now, is it also correct that July 17th, 2020 was after the loan would have come due, even if it had not been accelerated?
Yes, that is true that it was after the time would have come due. However, my client did specifically request it prior to that. Additionally, the provisions state that if no agreement can be met, that the deferment shall be up until the point that the loan would have matured anyway, is what the statute states. But in this case, the appellee did not even allow the opportunity to come to an agreement. They just did not provide it at all.
Did the letter, well, I guess I really have two questions. You have made a statement that your client requested relief under the Act before July 17th, 2020. I am not aware of anything in the record, either the transcript or the of the hearing below or elsewhere that supports that statement? Is there anything in the record that supports that statement?
No, there was nothing in the record to support that statement. It was an informal request that he made with a loan officer.
Now, another question I would ask you about this request is there's nothing in this, when I say this, there's nothing in the July 17th, 2020 request letter that specifically says that the borrower is having a hardship as a result of the pandemic. Do you think that is of any significance? The absence of such a statement in the request?
No, Your Honor, because the potential for deferment was supposed to be made available regardless. And then at that time, the applicant would have had to, the borrower would have had to state the reasons as to why it was needed. Additionally, in further amendments of the COVID relief, the COVID relief for mortgages in DC, it stated that that need to state that you were experiencing a hardship due to COVID was no longer required.
I beg your pardon. Say that again, please. The latter point you made.
Yes, Your Honor. Under the Emergency Act, the later amendments stated specifically that it was no longer required to state that you were having a hardship due to COVID in order to be able to apply for the relief.
When are those amendments?
Yeah, what later amendment are you referring to?
So the final one, as it states, as it stands now, it states that.
I guess I don't want to know what it states right now. What I want to know is the amendments you're referring to, when they were passed, specifically in relation to the court's denial of your request for injunctive relief. After?
I'm sorry, I didn't hear your question.
So you say that there's an amendment that says, you don't need to say that you have any hardship stemming from the pandemic. Did that amendment take effect before or after the trial court's ruling on appeal?
It was after the trial court's ruling.
So what do I care? I mean, if you're ascribing some error to the trial court and applying the law in effect at the time of its ruling, I guess I just kind of gloss over if you start talking to me about amendments that postdated the trial court's ruling.
Yes, Your Honor. However, the trial court did not make their decision according to its own order based off of the Relief Act. In fact, they just sort of did not consider it at all. It stated that that the bank, the financial institution, had exercised its right to foreclose prior to.
Counsel, I need to point you, because I want to give you a chance to respond. At page 5 of the trial court's denial of reconsideration, the very top of it, it says as a third reason that he was denying the relief was 423191.01C1 requires a mortgage lender to approve a deferment application only if the borrower demonstrates to the mortgage lender evidence of a financial hardship resulting directly or indirectly from the public health emergency, and plaintiff has not provided any evidence that its default in the fall of 2019 or its failure to cure the default results from the COVID-19 emergency. That to me sounds like he was denying the relief requested because there was not even an attempt to tie the default to a hardship, which would have been hard to do, seeing as how it preceded the public health emergency. But put that aside, there was not even an attempt to tie the default to the pandemic. I mean, I think he says that. Why? Your reaction seems to be he never said that. Are you sure?
So if that is what the order states, then that is what he said. However, that is a misinterpretation of the actual statute. The statute states that it demonstrates to the mortgage lender evidence of financial hardship resulting directly or indirectly, as it states. And it continues, and then there's an and agrees in writing to pay the deferred payments within. So I would argue that that part of the statute is for once after the application is provided and the application is being considered, that the borrower would then have to show that hardship. It did not need to be showed in order to just request the application.
It sounds like what you're saying is that even though the application would have been unsuccessful because the borrower had decided to go forward with a foreclosure action, because the lender had decided to go forward with a foreclosure action, there was a default, there was a lien on the property that was superior to the lender's lien. Despite all those things, the lender still had to go through the sort of motions of allowing you to apply and then denying it. Seems a little, it's hard for me I'm not sure that's a strong enough argument to say that the trial court erred in denying a temporary restraining order or other injunctive relief.
Yes, Your Honor. I believe that it wasn't strong enough because even if they were to go through the motions and ultimately deny that time in allowing for the application to actually be perceived and to show that he was having I never said that he did not have a financial hardship due to COVID. So he could have had the opportunity to show that, and he could have also potentially found another lender who could refinance the loan. So their denial of stating that they would not continue with the loan and that it would end at the maturity date without allowing any opportunities to apply for the COVID-19 relief as the statute relates did substantially harm the borrower. So back to the third question, the confessed judgment did not equal size exercising their rights. As the statute specifically stated at the time we were in the trial court, they needed to exercise their right to foreclose or to accelerate the loan. They did not do that. The time it was done was when a notice was sent in June. And I forgot to state at the beginning that I did want to reserve some of my time. So I have less than 2 minutes left. So I would like to reserve 1 minute for rebuttal.
Well, all right, let us hear from Mr. Drazen then, and we'll give you a minute or even a little bit more for rebuttal. Mr. Drazen, am I pronouncing your name correctly? I apologize if I'm not.
You are. Probably should be pronounced Drazen, but we pronounce it Drazen. Good morning, Your Honors. Russell Drazen, or Drazen, for the appellee, WCP Fund I, LLC. The Judge Epstein's denial of the petition to stay should be affirmed. The appellant did not clearly demonstrate a substantial likelihood that it would prevail on the merits. I'm happy to answer whatever questions Your Honors may have.
I guess I do have a question for you. For purposes of the Relief Act, it may matter when the lender here, quote, exercised its right to accelerate the loan. What does a lender have to do to exercise its right to accelerate the loan in this case?
In this case, Your Honor, there is no notice required under the loan documents or District of Columbia law. This is a commercial loan. There is no notice required to be sent to the borrower to exercise the right to accelerate. That was done by the lender internally.
Is your answer nothing at all then?
Well, the decision of the lender to accelerate upon a default. That is what needs to be done.
What evidence is there that decision was made before sending the letter?
The notice of foreclosure sale that was sent, that wouldn't have been sent had the loan not been defaulted and accelerated.
Well, I guess the question is, when was the loan? In other words, let me put the question a little bit differently. The Article 5 of the note, I think it's Article 5, says that when there's a when there's a default, the entire principal sum outstanding shall at once become due and payable at the option of the lender without further notice. Now, if we didn't have the statute here, the relief statute, I don't think any of this questioning would matter because no notice was required, I think, before the timely notice of a foreclosure sale was sent out. But the statute talks about the exercise of the right to accelerate, and the loan at Article 5 refers to it as an option of the lender. So I'm wondering if that doesn't mean we have to ask, when exactly did the lender exercise its option, if you will, to accelerate? If the lender did that before March 11th, then it was for that reason. Then for that reason, the Relief Act would have no bearing on this case. But if it did it after March 11, then the Relief Act might have a bearing on the case. Do you understand my question now?
I do, Your Honor. I don't think there is anything in the record that would reflect when the lender exercised its option to accelerate the loan. But I'm not sure that that's the important question. I think the important question is, was there a basis for the lender to exercise its option to accelerate as of a certain date? And in this case, it was clear from the record that the lender had.
You can make that argument. It's just that that's not what the statute says. It doesn't say if the lender has a basis to accelerate the loan. That says when the lender, exercises its option to do so, right? So you could see a certain situation where, there's a proverbial stack of papers showing that they're in default and the lender just doesn't get around to reviewing them and then eventually does and then decides. But we have no idea when this happened. And the only thing that's in the record that puts a time on it is the notice of foreclosure, right? So we have no idea if they decided the day that they drafted the notice of foreclosure or whether they decided, sometime earlier.
If, Your Honor, if that's the standard under this emergency legislation, then on this record, I don't think I can establish when that option was exercised. But what I can do, and what I did below and what I've done in the brief, is to establish that there was no evidence of financial hardship, which in and of itself is a separate basis to deny any sort of payment deferral under the emergency legislation. And then moreover, what is clear from the record is that the loan matured as of July 12, 2020. There wasn't a request made until July 17, 2020 for a payment deferral under the emergency legislation. No deferment beyond the end of the original term of the mortgage loan is permitted under the emergency legislation, regardless of whether the loan was earlier accelerated. So in this case, it is clear from this record that the loan matured as of July 12, and that when the request was made for a payment deferral, it wasn't available under the statute.
Excuse me a second. I want to pull my. I wanted to check something in the statute. May I ask you another question? There's been reference in the brief in the briefs, a brief, and to an April 8th letter from the lender to the borrower. That may be in the record, and it's just maybe my poor aging eyesight that has made it hard for me to find it. Is that letter available to us in the record on appeal?
It is. It is not.
Okay.
It was not part of the record.
I have not found it. That explains why. Okay. So your argument with regard to the statute is wholly apart from the March 11th date provision. Well, you said it a little bit categorically that the statute precludes granting relief past the end of the original term of the mortgage loan. I'm not sure that's exactly the way to put it. It doesn't require, I would have said, tell me if I'm wrong about my interpretation of this, I would have said that it does not require the lender to provide relief, even if all the other conditions are met, beyond where the beyond the original term of the mortgage loan. Is that?
I think that's that? I think that's right. And my point with Judge Easterly was that there are three independent bases under the emergency legislation that precludes, however you want to put it, that precludes the payment deferral that was first requested on July 17, 2020.
I understand Ms. Johnson's argument in response to that, putting aside the March 11th date issue. I understand Ms. Johnson's argument in response to that to be that even if that is true, that she should have been given, or her client should have been given the opportunity to, as it were, make its case for relief with the lender, because maybe either because it conceivably could have persuaded the lender to grant an extension and hold off the foreclosure, or because it would have bought time for the borrower to seek financing elsewhere to be able to pay off this lender. How do you respond to that argument?
Principally, Your Honor, I'm sorry.
If I've understood it correctly.
Well, if I understand it correctly, the way I would respond to it is that that was not part of the emergency petition that was filed below, and that's not an issue that is on appeal. What was filed below was a petition that, as I understand it, requested, and what was appealed is a request to stay the foreclosure sale on two bases. One, that proper notice of the sale was not given, and that was demonstrably proved at the hearing, the emergency hearing on July 27, to be not true, and we haven't even addressed that here. I assume that I don't know whether the appellant is conceding that at this point, but in any event. And then the second basis was that a request was made for a payment deferral under the emergency legislation, and it was denied, or it wasn't accepted. Those are the two issues. There were no other issues raised below, and there are no other issues appealed from.
Okay, I do not have a follow-up question for you.
Thank you, Your Honors. The Judge Epstein's decision to deny the petition to stay should be affirmed. Thank you.
Thank you. Ms. Johnson, we'll give you a couple of minutes in rebuttal. Ms. Johnson, you are on mute. You'll need to unmute yourself.
Yes, Your Honor. First, I do agree that the statute does not preclude from the financial institution from extended beyond the maturity date. The statute just states that they do not have to defer beyond the maturity date of the loan. Further, the issues on appeal is not just whether or not the appellant, excuse me, let me rephrase. The issue on appeal is, as stated, the questions are whether or not the judge erred in failing to provide the injunction, and as whether or not the appellee did not have to exercise its right to foreclose before March 11, 2020, and that the confessed judgment was the equivalent to exercising that right. The statute is clear that they did need to exercise that right, and they did not. In fact, they did not do it until the notice of foreclosure was sent. Furthermore, in
How do you know
Appendix
that?
84,
How do you know that? I mean, the record is silent, actually, as to when the lender made the decision. It's hard to know what exercising its option to accelerate means, because the lender does not, by terms of the loan agreement, have to give notice. So if the lender does something internally in its office and says, well, we're going to have to accelerate this thing, and I mean, it's hard to know what exercise means when the lender doesn't have to give notice. But isn't the fairest thing one can say that the record is silent as to when the lender exercised its right to accelerate?
no, Your Honor, I actually would argue that how do we know whether or not they exercise their right to accelerate is that a notice to foreclose was not provided until after the March 11th date. Clearly, that is what they did here when they exercised their right to accelerate and stated the foreclosure. So the fact that they didn't do that prior to March 11th, that shows that that is how they would have moved forward with doing so, and they did not.
You know, that does not sound right to me, because a lender can decide to accelerate, but then hold off on the notice of foreclosure for a lot of good reasons. I thought you might be intending to argue that the April 8th letter that you've referred to was the exercise. Now, I must tell you, I have a problem with that argument because we don't have the letter. It's not been made a part of the record. And we don't know what it said or, what have you. But I thought that's what you were going to argue.
Well, Your Honor,
Yes,
the April 8th letter can show that. And I would also say that the record continues to state that on Appendix 84, there's a section that specifically states that acceleration of a maturity once claimed by the lender may at its option be rescinded by an instrument writing to that effect. So that would be clear to me. That shows further, that's from their documents prepared by the lender, that they actually do there is a written record of when they choose to accelerate a loan, being as though that it can be rescinded in writing. There was no evidence of that here prior to their notice to foreclose. So that being said, that there was no acceleration that is spoken to in the record as required by the statute. Further, so there was no acceleration, even though the documents doesn't that a notice is required. Their notice of foreclosure clearly is how they choose to accelerate the loan and to move forward. They did not have any record, did not produce any at the trial or as a part of this record. So therefore, we state that the trial court did err and it should be overturned.
So thank you both. The case is now submitted, and the two of you may log off.
Thank you.
This court is now adjourned